Okay, number 19. Here we go.
So you had your wits about you, right?
I was still awake.
You were talking earlier also. Let me see that email we have. So they were doing moisture testing that week at your apartment, correct?
Yes, sir.
And you received an email from the staff at the apartment complex. And I think your testimony was that you guys were made aware that they were going to be doing certain testing, and then you testified that it was going to be like between the hours of, what did you say, 8 to 4, 8 to 5?
8 to 4, around there.
Or 8 to 5. So you can remember that.
You notice he keeps saying, you testified, you testified, you testified. And every time he gets her to agree to what he's saying as her testimony, when he misquotes her testimony or he says you testified to this and she says, no, I didn't, and he moves on, he's already planted that seed so many times that the jury may not catch when she disagrees with what he testified to, because she's agreed with him for 20 times. That's why he shouldn't be doing that.
There was a specific time given, right?
Yes.
Can I approach this witness, Judge?
Yes.
I'm showing you Mr. Mark for identification as State's Exhibit number 319. Can you read the portion down here and tell me if this is the email that you received indicating what was going to be happening the week of September 4th through September 7th?
Yes, it is.
Okay, and I'm going to let you read the...
Is it wrong that I just kind of want to slap those glasses off his face? Rick, you can't say he's a little punk. He's picking on a woman that can't fight back, being a jerk, thinking he's a big tough guy in front of the jury. Go home and feel proud that he manipulated the system and manipulated somebody who couldn't fight back. What a punk.
Did you read it all the way to there?
Yes, sir.
Okay. And the second page.
Yes, I did.
Okay, so this is going to be an email that looks like it was sent out to all of the residents by name, correct?
Yes, sir.
All right. There's no time in there, is there?
It's an all-day event to me, as like normal working hours.
Well, but that's not what you told the jury. You told the jury a specific set of hours. You understand your credibility is absolutely...
Really? They sent an email saying we're going to be doing this all day. Is it reasonable to think it's 8 to 4? I mean, how hard is that? And he is questioning her about her credibility and how she lied to the jury. He's banging on the table to make a point, to let her know that he's in charge, towering over her, standing between her and the jury because he's the jury's friend, and the jury and him are buddies, and she's the enemy, and he's talking down to her. Out freaking outrageous what this punk just did.
You told the jury a specific set of hours. You understand your credibility is absolutely critical.
Judge, we're legit to the sidebar.
Sustain.
Do you understand that your credibility is vitally important in this case?
Yes, sir, I do.
Do you agree that there is absolutely nothing in this email that says it's going to be conducted between any specific set of hours?
There's not.
You've lived in an apartment before, is that right?
I have.
As have I.
I can't believe the judge didn't do a sidebar. I mean, he was being a complete jerk. And the judge just... That's why I kind of had a problem with the judge, is because she seemed like she's allowing the DA to do what he wants, and she always kind of lets the DA get away with shit. I'm just... Oh, man. Outrageous.
And in apartments, maintenance happens, correct?
Yes, it does.
Emergencies happen, right?
They do.
And in your lease, I'm sure you know, and you tell me if you don't, that they can send in folks, like if you have a pipe that bursts or if there's an electrical fire, there may be an occasion, day or night, where someone may have to go into your home.
Yes, that's true.
That you know this, right?
Yes, I do.
Okay. And did that reality factor in to your decision at all? Did you even let that get, in your thought process that there might be somebody who is legitimately inside there before you shot?
No, sir.
But yet you knew that too. You knew that could be a possibility.
what would be a possibility?
There may be a legitimate maintenance issue. You just don't know.
Okay.
Did you even think about that?
Not that late at night.
Okay.
Well, see, he's got her on such the defensive that she doesn't want to defend herself. She should have went, I don't know what the lease says, but it normally says during normal business hours. It doesn't say at night. And a lot of leases says if somebody's in there, they got to leave the door open. They can't shut the door while they're in your apartment if you're not there. And they'll say they'll reschedule when you're there. So I don't know what the lease says, but that might be something to follow up on. But it's not a real critical case, and you don't want to keep your client on the stand in order to research that and get that. But from her standpoint, from a witness defending herself, she should say it was late at night, and I didn't think that. And if it would have been a maintenance man, the person wouldn't have charged me when he saw me in a police uniform with my gun out telling me to show his hands. If a maintenance man did that and charged a police officer in uniform that was pointing a gun at him saying, show me your hands, then I probably would have shot the maintenance man thinking he was a threat also. Now, that probably wouldn't have been the greatest thing because you don't want to make it seem like you want to go shoot people. But I don't know if they should readdress that or whatever, but he made it sound like she doesn't think, and she wasn't thinking. And she, again, totality of circumstances. It happened quickly. She thought she was in her apartment. She saw somebody in her apartment. She drew her gun. She challenged. The person came at her, yelled, and she fired. It was a bad shooting. She shouldn't have shot. The guy shouldn't have died. I'll say it for the 100th time. But it was a mistake of fact, and there was no intent of her to kill anybody. Even though the DA got her to say that she wanted to kill him, it's still wrong. I still don't believe it.
Okay. You also, in your testimony with Mr. Shook, indicated that you were concerned about some of the crime, because you do a lot of background research, right?
Yes, sir.
And you had been concerned about some of the stuff that was going on at the Southside Flats, right?
Yes, sir.
I don't think she said she was concerned. I think she said she was aware that there was crime and that there was homeless and they were climbing. I don't think she ever used the word concerned. That's why you don't want a DA telling you what you testified to, because he's added in that you were concerned. And I do not remember her saying that. I could be wrong.
That would be an additional reason, though, for you to be even more vigilant and observant, correct?
You could say that.
I mean, Ms. Guyger, are you aware that you've got over 3,250 training hours?
Yes, sir.
3,250 training hours. That's good. That helps with her saying it was muscle memory and she was acting to her training. It can also hurt that she didn't do something that she should have done. I don't think she would give. Most cops are not taught to give first aid. I've said it before. Even though we're trained in first aid, we cannot get sued for not giving first aid. We can only get sued if we give first aid inappropriately and do more damage. So the only way that you can get sued as a cop for giving first aid is to try and give it. If you don't give it, you cannot be sued. You don't like it, you may not like hearing it, but those are the facts, and that's why most cops do not give first aid. That's why I rarely gave first aid, especially if I'm chasing you and you crash and you endanger my life. I'm letting the professionals who do it for a living, the ambulance will get there and they can give first aid. I can't remember in all my years ever giving first aid to anybody. Now, you may think I'm a jackleg, bootleg, mean, bad, evil person, but you know what? I never got sued for giving inappropriate aid or for giving aid and doing more damage. Your choice. I made mine, and I'm okay with it.
You are not like a regular citizen like me. You've got thousands of hours of police training, right?
Yes, sir.
You're absolutely right. This is what her answer should have been. You're right. Which is why I reacted the way I did, and which is why the Supreme Court has ruled that officers must be judged on their training and experience. And any officer with the same training experience that I've had that you've just referred to would have done the same thing I would have done in the same circumstances, which is exactly what the Supreme Court says I'm supposed to be judged on. That would have been my answer. Come on, lawyer boy, let's play games.
Your job requires you to be observant and aware of your situation, right?
It does.
And as a matter of fact, your job with CRT, the interview position, the only reason why you could be there is because you showed an acumen and a skill for things like observation and situational awareness.
Yes, sir.
Right?
Yes, sir.
So see, he's using, this is the old ego trick. If I stroke your ego, you'll agree with me, and then I'm going to rope-a-dope you and use that against you. So he's stroking her right now saying, yeah, you were picked for a special team because of your special training, and you've got all this training, and you know everything. And now in this incident, you totally ignored all your training, and you didn't do what you should have done. That's how it's going to turn out. I haven't even watched it, but we'll see.
When you were talking with Mr. Shook on direct examination, you had indicated, that this place here caused you some concern because of all of the bad stuff that was going on, right?
I did.
Do you remember having a conversation? Do you know a person by the name?
I don't remember exactly what I testified to, but I do remember that I was aware that there were robberies in the area, and we had homeless climbing the fence, and there was crime in the area. What you just said, I'm not sure if I said that or not, because you keep testifying on what I said. And unless you show me what I said, I'm not going to agree to what you say I said. So if you want to show me what I said, I'll be more than happy to go over it with you. That's how you shut down these freaking cheap lawyer tricks. And of course, he's going to object. Your Honor, can you instruct the witness to answer my question? I just did answer his question, Your Honor. He keeps trying to imply that I said things that I don't think I said. And if he's going to refer to my prior testimony, I'd like to see what I said, because I've said a lot of things and I don't want to misquote or misrepresent myself to a jury and then have them think that I'm changing my story or I agreed to something that I didn't necessarily say. All I'm trying to do is make sure we're all on the same page and we're getting the truth out and the jury has the correct and truthful information, not what the attorney keeps wanting to say he believes is true. I'd have slammed his butt.
Name of Chamberlain.
Yes, sir.
All right. You remember having a conversation with Chamberlain by text on August the 21st of 2018, where he asked you, how do you like your new place?
I do not remember that,
May I
sir.
approach the witness?
Yes.
All right, Ms. Guyger, would you take a look at this text exchange?
Absolutely nothing wrong with her saying, I don't remember that. A lot of people don't want to say that. They think it sounds bad. But, if she said it to every question, then it becomes bad. But if you don't remember or you don't know, say it on a stand. Much better than trying to guess and fill in and be wrong.
And tell me if this helps refresh your recollection with Mr. Chamberlain.
Notice the condescending, the looking over the glasses, the not looking at her directly, the sliding it over to her with contempt. Dude, you're a punk! What a freaking punk! You can pick on a woman that you're sitting in a prison and can't fight back. I wonder what you're like out in the real world when you're not in your little courtroom with your little clown suit on. Oh, this guy irritates me.
I don't remember ever sending it, but I did. Obviously, I did send it.
Okay. And when asked about how you felt about the Southside Flats, your response to him, again on August the 21st, was, I'm liking it, right?
I did.
And then you said, few homeless here and there, and a lot of hippies smoking weed.
Yes, I did send that.
All right. You didn't say anything in there about the rank crime and all this other stuff that has caused you to be so concerned, right?
I did not.
And Chamberlain, he's a police officer, isn't he?
She is.
She is. I apologize. She's a police officer, right?
Yes, sir.
So to a fellow officer, you're not gonna hold back. Is that right?
I can't say I would or wouldn't.
Well, that's what you said, though.
I did say that.
See how he got to end it on his terms when it wasn't going his way? She should have said, This is an email between another cop. Cops aren't going to sit around and talk about crime when we have to deal with it all the time. She asked, it was a casual conversation. She asked if I liked it. I said, I do. There's some hippies smoking weed. You're trying to make this out of some, logical where we planned a search warrant and we need to get witnesses. That's not the way it is. And your implication that is something more than just an email between me and a fellow officer is BS. Oh, you can't say BS on the stand. Oh, BS, you can't. I'd have called this guy out in a minute. Man, there would have been no doubt in anybody's mind that me and this dude did not get along, and we are not friends, and we ain't partners, and if we see each other again, well, however the movie goes.
Some people smoking weed, but you're liking it.
It's what I said in that message.
But today, in front of this jury, it sounds like all kinds of mayhem is going on.
Yes, sir.
She should not have said yes, sir, to that. What's the question? I think he just made some off the cuff, but in front of the jury, there's all kind of mayhem. I don't think I used the word mayhem. I think I said this. Would you like to pull up my prior testimony?
You remember when you were testifying on direct with Mr. Shook, on a couple of occasions you indicated that you wanted to become a police officer because you wanted to help people.
Yes, sir.
And then a second time you took the opportunity to tell Mr. Shook that becoming a police officer was important because you could help people, right?
Yes.
Do you recall working the MLK parade on January the 15th, 2018?
Yes, sir.
Not a plea approach.
See, the other attorney wants to approach a lot. I think he needs to get his objection in front of the jury and let them know what this DA is pulling. Because when they go over there, the jury doesn't know what they're talking about. They don't know that he's wrong, and they have to guess on what he's complaining about. Whereas if he made his objection orally to where the jury could hear, then he can educate the jury on what a sleaze this DA is.
Is that right?
Yes, sir.
You see that bright red floor mat there?
Yes, sir.
You don't have a floor mat in front of your apartment, do you?
I do not.
Would you agree with me that there is no other bright red round floor mat
It does.
anywhere on the third floor or the fourth floor as best you can recall?
It doesn't appear that way.
And you see these.
A better answer would have been, I didn't see that doormat, and I don't make it a habit of looking at doormats, so I can't tell you whether there is or is not doormats on other places. I would have to go check, because I just don't check. That's not something I look for when I go home.
Doors right here, and this wall column right there.
I do.
That's exactly the same as it is for your apartment, right? You know that they're there.
Yes, sir.
Okay. And that would have been a perfect place for you to take cover and concealment, stepping back just a couple of feet from that door, had you chosen to do that.
It could have.
Shit, I don't know how long this testimony is. I'm at 20 minutes again. All right, let me pause this and we'll get to the next one.